Thank you, Mr Speaker. I ask leave of the House to move amendments 1 to 3 on sheet 1 and amendment on sheet 2 as circulated in my name together.
The call to the Attorney-General.
Leave is granted.
Leave is granted. The member may proceed.
As circulated, and on amendment 1 on sheet 2 as circulated in my name together. It's impossible to properly scrutinise this legislation when it's provided to members only hours before debate. It makes a mockery of our responsibility to carefully scrutinise laws. Despite this and my serious concerns about this bill, an extremely limited amount of time, I've been able to at least draw out these 4 amendments of areas that are contentious and incredibly concerning. In seeking to act quickly, this bill grants the minister broad discretion with inadequate safeguards, weakens procedural fairness and sets a dangerous precedent that future governments could exploit. My concerns and amendments address 3 areas: the breadth of ministerial power, the lowering of visa cancellation thresholds and the narrow, incomplete definition of hate crime and consequently prohibited groups to which that applies. As drafted, it enables a significant overreach of ministerial power, weakens procedural fairness and sets a dangerous precedent that may be exploited. Now, in relation to my amendments, the revised bill circulated just recently is intended to combat anti-Semitism, hate and extremism. That is something I would hope we are all united about. But the execution is flawed and unacceptable. The bill continues to define hate crimes narrowly, focusing on race, nationality and ethnic origin, which I certainly welcome that. But it is clear that we have hate crimes that are done on the basis of faith, that are done on the basis of sexuality, gender and sexual orientation and disability. And why these are not included in the definition of hate crime for the purpose of prohibited groups, I do not understand. And I know many in Australia, in such a multi-faith country, why on the basis of at least religion is not included is really quite astounding. So one amendment seeks to broaden the definition of hate crime, to expand it to include targeted people on the basis of religion, sex, sexual orientation, gender identity, intersex status or disability. We know hate does not stop at race or ethnicity. There is no justification for excluding those other communities. I know they are quite distressed at the moment at hearing the debate in this place and in hearing that the government is not caring about the hate that they face. Narrowing the definition of secular pastoral leadership. As drafted, the bill criminalised conduct by anyone providing religious or secular pastoral care. Secular pastoral care is not defined. That term has no clear legal meaning and no settled boundaries. The amendment, and I have consulted with academics and legal experts in relation to this. The amendment removes the concept of so-called secular pastoral care leader entirely and limits the offence to genuine religious officials or members of prohibited hate groups. With this change, the risk of unintended consequences, and I would say a constitutional challenge that will be an embarrassment for this government, is important. Finally, the visa cancellation threshold. This bill changes the legislation in relation to the discretionary power of the minister that can cancel a visa on the basis of a concern that someone would commit an offence to might. Now, that dramatically lowers the threshold for cancelling a visa and for consideration. Might is entirely speculative. On a balance of probability, you could say that on the basis of a chance of 1 out of 100, that is a might. Would requires already slightly higher consideration. My amendment seeks to include that where a minister seeks to cancel a visa based on speculation about what a person might do, should at least make clear that there must be a demonstrable and reasonable risk. That is not an objective test. It invites an arbitrary decision-making and broad discrimination. The amendment seeks to make clear a defensible standard, one that respects the rule of law while maintaining public safety.
The question is the amendments be agreed to. Give the call to the Attorney-General.
I thank the member. The government does not support these amendments for the reasons provided in response to the amendments of the member for Wentworth. In addition, leaders of prohibited hate groups would already be subject to penalties of up to 15 years under this bill, and so it is unnecessary to extend the aggravated offences for religious leaders, which carries penalties of up to 12 years to them.
The question is the amendments be agreed to. I'll put